Okay, good afternoon, everyone. I think we are now live. We are here today to present arbitration versus litigation. Which venue better serves your business? My name is Michael Hensley. I'm principal and co-chair of the business litigation group here at Bressler, and I'm going to be serving as the moderator, but as you'll probably notice soon, more of a referee for today's presentation. The theme is really one size does not fit all. Every business is different, different capital structures, different risk tolerance, different challenges. And so in the event of a dispute, evaluating whether litigation or arbitration is the most favorable forum for your particular business is obviously would require a fact-intensive inquiry. So today's presentation is geared towards a robust debate among the pros and the cons of litigation and arbitration. And you're going to hear from some of the best. You're going to hear from our first chair trial and arbitration attorneys who've all been in the trenches, which will hopefully enable those attending today to apply some of the factors they are going to highlight as pros and cons of litigation and arbitration to their specific business models. And as you will see, some of our panelists have their clear preferences. So by way of brief introductions, Sarah Soto is a principal in Bressler's Alternative Dispute Resolution Group, as well as the Business Litigation Group, and it has arbitrated and litigated a number of cases, including the representation of brokerage firms, corporations, and individuals in a variety of matters. Lauren Valdivia is a principal in Bressler's Business Litigation Group, and she has represented companies and first chair jury trials in a wide variety of matters, including employment cases, commercial cases, as well as professional liability cases, and just recently won a jury trial in an employment case. Catherine Perot is a principal in Bressler's ADR and business litigation groups, as well as the securities practice area. Catherine has litigated and arbitrated in a number of different areas, including securities, regulatory investigations, and employment disputes. And last but not least, John Kincaid is a principal in Bressler's Financial Institutions Group. John has handled a number of matters involving both federal and state securities litigations and arbitrations, as well as regulatory enforcement, including just recently defending a bank in a AAA arbitration arising from alleged breaches of oil and gas commodity swap contracts. So before we get started on the substance of today's presentation, we wanted to at least poll about preferences of our viewers as to arbitration litigation, and then we'll get into the meat and potatoes of this. So the first question we'd like you to answer, and we're going to ask these questions at the end of the presentation as well, is which forum do you most frequently utilize? Arbitration or courtroom litigation? We'll give everyone a couple of seconds there. Okay, everyone locked in? About evenly split. You couldn't get it more close. 51% arbitration, 49% courtroom litigation. Okay, one more polling question I believe we have before we get into the guts of this. Regardless of what your business does, which form do you actually prefer? Do you prefer arbitration or do you prefer courtroom litigation? Get a couple of seconds to answer. Okay, it's actually just reversed that time. So someone out there, that 1%, is doing something they don't prefer to do. But regardless, that's very interesting that it's so split down the middle. So I really think that this is going to be a timely presentation about the differences, the pros and the cons of arbitration, to see if those numbers change at all after you hear our esteemed panel debate some of these topics. So we're going to really try to tackle, if time permits, 3 different areas. The first is the pros and the cons of arbitration and litigation. The second is geared toward drafting. So to the extent you believe that arbitration is the most suitable form for your business, what kind of terms and what latitude are you given and what are your options in drafting your arbitration provision? And then although we'll touch on this throughout the presentation, we can also offer some thoughts at the very end about appeals of arbitration awards. So with that said, let's go to the pros and the cons. And certainly there's a number of factors that we identified that people perceive as having a distinct difference between litigation and arbitration. Cost is obviously on the forefront of every business mind. So with the perception that arbitration is less expensive than litigation, Sarah, can you talk a little bit about costs and when weighing costs when you're choosing between litigation and arbitration? Is it really cheaper?
Yes, that's the bottom line. And I would attribute that mainly to two factors. The first factor being the scope of discovery that's generally permitted in arbitration versus in court litigation. And the second factor would be the essential unavailability of post-award proceedings such as appellate review. There's such tremendous cost savings generally in arbitration versus litigation in this area that I think most everyone that's had experience with both has come to the conclusion that, yep, arbitration is cheaper.
All right, Lauren, let me throw it to you because I know when I file a litigation, it's about 400 or so bucks. But when I file a statement of claim in arbitration, and it's the tune of a couple thousand, do you agree with Sarah that in fact arbitration is inherently cheaper?
So obviously, initially litigation is going to be cheaper, but as the procedure goes on, litigation, I must concede, will be more expensive typically. But really that's because you get what you pay for. The benefits of broader discovery that come with courtroom litigation, I think, are unparalleled. Sarah and I have been on opposite sides of this debate as long as we've known each other. And this debate tends to be what we talk about at least once a month or so. But as we talk about it, yes, I have to concede that litigation tends to be more expensive, but that's because you have a greater ability to obtain discovery, both written discovery from your adversary as well as depositions. And typically, when you take a deposition in a case, in a litigation, it's really giving you the ability to test the witness, to test the veracity of what they're saying. And also, it's the only time that you're really getting to speak to the other side, and it's not really filtered through counsel. So the ability to obtain discovery through the litigation process, yes, it can be a little bit more costly than an arbitration, but it also gives you the ability to prove your case or disprove your adversary's case. So I guess, although I'll concede the point, I would end with the thought in terms of cost that you're really getting what you pay for in terms of the scope of discovery, motion practice, especially when you're dealing with complex, nuanced issues. And I'm sure Sarah and I will be able to talk about appellate rights as we get further along in this section.
Well, let's talk a little bit about that scope of discovery and highlight for our viewers some of the distinctions between courtroom litigation and arbitration. So Sarah, when I have a lawsuit, I know I'm getting my interrogatories, unless I'm in the Southern District of New York, which I get like 3 only. I know I have my request for the production of documents. I have my request for admissions. I have my set amount of depositions. What are the differences in arbitration?
Arbitration can be made very flexible from the standpoint of the scope of discovery if you make an agreement to that in advance. But generally speaking, unless you've done something like that or you agree in the course of the arbitration, discovery is essentially going to be limited to document discovery and maybe a couple of depositions. In the case of international arbitration, not even a couple of depositions. My disagreement with Lauren here would be that in taking depositions, interrogatories, etc., you often do not get what you pay for. A lot of times a deposition is taken and it's a waste of time. There's definitely something to be said for meeting a witness for the first time in an arbitration proceeding and having his unfiltered and unprepared answers given in front of the arbitration panel, whereas previously taking a deposition often serves as a tool for the witness to prepare him or herself for the testimony at the hearing. So I would say that in the terms of the scope of discovery, most of the world manages to solve its civil disputes without taking any depositions. And I would say that we can manage to do that too in an arbitration proceedings. And I do not believe that ultimately it affects the result. Plus, in addition to money, which of course is part of the cost of everything, there is the cost of the time spent by employees of corporate defendants parading through lawyers' conference rooms or on Zoom, preparing for the depositions in advance and all that, which is hard to put on a balance sheet, but I think everybody would acknowledge it's a real cost.
Well, let me push back a little bit on that, Sarah. So when we're talking about arbitration being cheaper, I know in the litigation world, we'll take depositions with the hope that maybe we'll win a dispositive motion at the end of the case, which we won't even need to pay for a trial. Are dispositive motions permitted in arbitration? And if so, how does that factor into your analysis about really not having the ability to take depositions to support any dispositive motion at the end of whatever fact period you're allowed?
Generally speaking, not everywhere. There are forums such as FINRA where dispositive motions are very, very limited. So if you have a good defense of the statute of limitations or something like that, you're not going to be able to get that motion granted before hearing at a place like FINRA. But at the AAA, JAMS, and most other of the commonly used arbitration forums, yes, dispositive motions are available. You may have to ask the arbitration panel to give you leave to present a dispositive motion, but generally speaking, assuming that you actually have a decent basis for a dispositive motion and a decent chance the panel will take it serious, you have also a decent chance that you will be given leave to file your dispositive motion. So that generally is available in most commercial arbitration forums.
Well, let me throw it back to you, Lauren, because what I'm understanding then is that I'm going to have a limited amount, if any, of depositions to take in an arbitration. What about experts? So, in court, depending on what state you're in, if you're in federal court or anywhere other than New York State court, I'm going to get likely an expert report. I'm going to be able to vet it. I'm likely going to be able to depose that expert, maybe use that to file a dispositive motion or a motion in limine. In New York State court, we'll get an expert disclosure 30 days from trial. So I guess that's similar to arbitration, is that we don't really get a report or depositions. How does the expert angle in discovery flavor your opinion as to whether you prefer litigation or arbitration?
So it works the same way. I certainly would want the ability to test the veracity of an expert's report or their opinion through a deposition, particularly to the extent that I want to file a motion in limine. But I guess this goes back to the greater point on the access to discovery, which is that by virtue of us having greater access to discovery, whether it's written discovery through requests for admissions or depositions, either of a party, a witness, or an expert, you're essentially able to narrow the issues. And frankly, that might actually cut down on the cost of litigation because one, you've either narrowed the issues for the purpose of trial, or two, maybe it leads to a resolution of the case because you've successfully narrowed the issues through a dispositive motion or a motion in limine. So again, I think that the access to greater discovery, whether fact discovery or expert discovery, can actually lead to these cases being decided in a more efficient way. And then lastly, I would just say that when it comes to expert discovery, we're talking a lot of times about complex, nuanced issues. That's why we're involving experts to begin with, because of the complexity of the issues. So I want to ensure that I have the ability to test the veracity of those opinions and maybe make some motions throughout the course of the litigation to ensure that I'm not getting short shrift on some of these complex, big picture issues, especially to the extent that it's a case with a lot of exposure.
Sarah, thoughts on experts?
You're going to get that chance to do all that at the hearing, Lauren. You don't need to do it necessarily in advance. And particularly if it's an area where the lawyer already has experience in dealing with the issues that the expert is going to testify about, or the product that is involved in the arbitration, or alternatively, you will of course get your own expert to inform yourself of the areas of vulnerability of the other expert's opinion. So once again, I'm not saying there's no value, because that would not be true. But I would say that there's limited value compared to the cost, delay, etc., of taking the expert's deposition, of being able to do it in advance of the hearing.
Well,
Well, Sarah,
the only thing I would slightly push back on, and I think the one thing Sarah and I do agree on in terms of arbitration versus litigation, is a lot of this is going to depend on the subject matter at issue. You know, if you're talking about complex, high stakes cases, then I think that there are going to be benefits. Certainly, Sarah will agree with me that there are benefits to litigation, to having full use of the rules of evidence, full use of motion practice, and appellate rights that, you know, might weigh further in favor of litigation over arbitration. So it really might just depend on the subject matter here. I think that's the one thing we can agree on, Sarah.
I have no disagreement with the fact that each forum has its pluses and minuses. Neither one is going to solve all of the problems, but by the same token, I've been involved in arbitrations involving, $30 million in dispute with complex products, etc. And I can honestly say I did not miss having the extensive discovery. I just did not miss these things. I think that ultimately the result proved to be about the same as it would have been if it had been in the courthouse. But every case, of course, is going to be different. And I agree 100% that both of these sites have their pluses and their minuses.
well, let me just interject then, and let's switch gears a little bit from the scope of discovery between arbitration, litigation, to privacy. So Sarah, can you educate our audience a little bit about, the privacy of an arbitration versus open courts of a litigation, and whether that works to a business's benefit?
Our arbitration, generally speaking, is a private proceeding. The records of the arbitration are not available to the public. You can't get on the internet and access the court site and read what's going on. And the awards, generally speaking, are not public. When some forums do make them public, they make them available with redacted information. Again, it depends on the forum that you are in. If you're a FINRA, which is where most broker-dealer arbitrations are conducted, you will get a list of the awards rendered by each member of the arbitration panel, and you will be able to access the award with all of the information that the award contains. But generally speaking, in commercial arbitration awards are private and not available to the public.
Well, Lauren, can you think of any advantages of making it public and actually being an open court that would favor one's business?
Certainly. So I would suggest that when you're talking about a business that deals with duplicative cases, there might be a benefit to having some results out there to serve a deterrent purpose. I know that a lot of clients, especially corporate clients, prefer to err on the side of privacy, not having as much aired out in court as possible. But I do think that when you have a corporation that faces duplicative, similar types of litigations in a cyclical manner, there could be a deterrent value in really fighting some of these cases, getting some good results, and then being able to publicize those good results to serve as a deterrent, perhaps to the plaintiff's bar, since I tend to be a defense attorney.
Well, let's talk a little bit about that, because I imagine there's also precedential value that in open courts you could rely upon, important to certain decisions to be in your favor. But let's talk a little bit about evidence. And you mentioned evidence before. So there's the perception, please tell our viewers whether it's accurate or not, that the rules of evidence are just less strict in arbitration versus federal court or regular court. Is that true?
Yes, that would be true, because the rules of evidence are subject to what the arbitrator interprets them to be. And a lot of arbitrators are really quite liberal in terms of what they allow in, since they are under the misimpression that their award is more vulnerable if they keep something out than if they let it in, which is a misimpression.
Well, Sarah, if I could just interject, is that a wise move for businesses? Do they sacrifice anything in the merits by giving up some of the rights under the rules of evidence in an arbitration versus having all those rights in the courtroom?
Okay, so I'm going to say that on the surface, it may look that way to you. However, in reality, most arbitrators are lawyers or are very experienced business people, and therefore they understand the concept that I saw something is not the equivalent of Mike told me he saw something. And so even if they were to allow the testimony that Mike told me that he saw something, they are not going to give it the same weight as if I said I saw something.
And Lauren, what's your
My-
take on that? Do you have a preference as to a more rigid application of the evidence rules versus we'll let everything in?
So my response to that would be, it sounds like you're giving a lot of deference and discretion to individuals who then aren't really subject to appellate review. And that makes me a bit nervous. I think that we have rules of evidence for a reason. You know, we all suffered through the class in law school and then suffered through the bar as well. And so to me, you know, when we're talking about the way in which evidence gets in, and then combining that with the lack of appellate review, I would be loath to leave that to the individual discretion of one individual when their decision will likely be the be all and end all at the end of the day anyways.
Well, let me push back a little bit on that, Lauren. So you say one individual, but okay, this kind of brings us to our next topic between would you rather have in a major case involving one of your major clients, would you rather have 6 or 8 strangers who have no experience whatsoever in the industry that you're about to present to the fact finder, i.e. the jury, or would you rather have someone, 1 or maybe up to 3 people who are trained, have 30 years experience, who've done nothing but this particular industry, they know the law inside and out? Doesn't that factor into whether or not you want to be in court before a jury versus in a arbitration with a professional, even though you might have let all the evidence in an arbitration?
Certainly. So juries, you know, are a bit scary, certainly to the extent that they are, you know, lay people, they tend to be sympathetic creatures. And to the extent that you are representing a large corporate defendant and the person on the other side is an individual, there's always the fear that you're going to deal with runaway verdicts or sympathetic juries who are going to decide based on their own emotions rather than the law in front of them. The only response I would have to that is we do then have the ability to have some appellate review. And I think I would prefer to give a decision at the end of the day to, you know, 6 or 8 individuals who are going to have to come to a consensus, knowing I'm going to have the benefit of appellate review, at least at some level, than 1, maybe 3 on a panel in an arbitration where that appellate review is not going to be available. So it's not an ideal situation, especially when I largely represent corporate defendants in high stakes litigation, and I'm dealing with potential sympathies coming out of jurors. The only slight pushback I would give is that I do think that sometimes juries can see through when it's a fact sensitive case. They have the ability to ascertain credibility. They have the ability to kind of determine if their nonsense meter is dinging or not. So the answer is it's not ideal, but I think I'd still pick the jury any day of the week with appellate review over the arbitrators.
Well, let me ask you this, Sarah, and we'll close out this topic then. So, you know, in your experience, is it more common to have a runaway verdict with a jury despite having appellate review that Lauren mentioned, or to be doing away with the runaway jury in arbitration despite not having appellate review? Does those factors play into a role in your decision-making as to whether arbitration or litigation could be a more favorable forum?
I can only speak to my own personal experience. You know, I've been pretty lucky from the standpoint of juries not making a result that I was really, really unhappy with. I would say, having said that though, that the jury is going to make its fact findings in its own mind and for its own reasons that you're never going to be able to look into, and that is never going to be subject to appellate review. So on balance, although I have the highest respect for juries, because I really do think juries try very hard to do the right thing, it's not worth it. I would rather have the experienced person who is more likely to understand and apply the law involved and not have the appellate review than have the jury do it.
Yeah, and one of our viewers also just mentioned in the chat, well, it's not always just jury or arbitration. It also could be a bench trial, and you can have those provisions in your contract. But just to highlight, those bench trials are still going to be public and not private. They're still going to be subject to the rules of evidence instead of a little bit more lax standard. And you're going to have the right to all of your discovery mechanisms instead of culling that back a little bit in arbitration, which could make arbitration cheaper. So with that, I'd like to change gears a little bit and get Catherine and John involved. Before I do, let me give my most important job, my number one job today, and that is the CLE codes. So I'll give two codes out. The first code is FEAR, F-E-A-R. It'll come together in the end. FEAR, F-E-A-R.
Mike, I do see that we have a question in the chat that may be answered a little bit by John and Catherine as we talk about the different forums for arbitration, but there is a question in the Q&A function.
Okay,
Yes.
and this talks about payment of fees. So
Right.
let me introduce this next topic, and I think we're going to cover this in the next section. But now that we kind of did a debate, if you will, over the pros and cons of arbitration, let's now switch gears. Let's assume we believe that arbitration is the most favorable form and you're writing your arbitration provision. Well, what are the options available to you in drafting these provisions? And do these drafting options, can they address some of the concerns or the cons that you just heard relating to arbitration? And so the first thing we'd like to tackle a little bit is the venue and some rules. What are your options? Because there's a number of arbitrable forums, including AAA, JAMS, and many others. But John, can you just introduce our viewers to AAA and talk a little bit about that before turning it over to Catherine to talk about JAMS?
Absolutely, Michael. Thank you. And following up on that excellent discussion of the pros and cons relative to AAA, I assume most of our participants are familiar with it. It's the largest forum for commercial disputes and a lot of subject matter disputes. It probably has the most developed rules and procedures of all the forums, and it is the one that is most used. The rules that are standard within AAA are generally designed to continue the elasticity of the process within arbitration without losing some of the guardrails that you need in any type of dispute resolution forum, and without getting it so much into bogging it down where it can become full court litigation, rules of procedure, rules of evidence, extensive discovery, and such. The AAA is known for commercial arbitration, as I mentioned, but also a number of different subject matter, specifically construction, employment, labor, consumer, and then within commercial, I think most people are aware for large complex claims that are over $500,000 in dispute, they have some additional rules that apply in that situation, especially as it relates to deposition and others. Looking at some of the key rules that you're going to see in AAA, it's going to be the location of the claim, where it's going to be heard. And that's something that the arbitrator or the arbitration panel is going to decide if you don't write that into the agreement. And Catherine's going to talk about some of those issues. But also AAA has what I think is recognized as its national roster of neutrals. And as a part of that, it has a very robust conflicts program to weed out conflicts of interest from the arbitrators and also for the neutrals, the parties, and the counsel. So when you put all that together, I think that's a strong process that they have that's important in any arbitration. You have a pre-hearing exchange of information and documents that you intend to rely on at the hearing. That's not a...
I think we have a pause. His internet was maybe.
And then it's permitted for relative to, Michael, are you hearing me?
Yeah, we are now.
All right, good. I saw my internet instability pop up again, so I was wondering that. I was talking about the pre-hearing exchange of information and the documents that you will turn over in arbitration, documents that you intend to rely on at the hearing, and the identity of the witnesses. In addition, AAA allows for reasonable document request that a party that are not otherwise available to a party that the party believes to exist. Most especially is the silence in the depositions. There is no provision in the AAA rules for depositions. So unless there is a pre-dispute agreement as to depositions or an agreement post-dispute between the parties and their counsels to take depositions, you need to, I think, assume that depositions won't be allowed in AAA arbitration. However, if you are in one of those large complex cases that I talked about, then within the discretion of the arbitrator, in exceptional cases and upon good cause shown, you may be awarded a few depositions. I think in a large complex case, you're going to get them, even if the other side is opposed to them, but that's just something to be mindful of, as the rules say. The scope of the award under the rules for AAA is very broad. The arbitrator can grant any relief or remedy that the arbitrator deems just or equitable within the scope of the agreement. So then again, that's very broad, and you've got to decide whether that's what you want to have or not. Going to the question that one of our audience raised, within AAA, the panel must assess the administrative fees, the arbitrator cost, as well as the hearing expenses, witnesses, bringing in witnesses, any third-party discovery that had cost associated with it. The panel can split that or assess it however they deem it. They can split it 50-50. They can do it 100% to zero. And so, looking at the defense, the commercial party that says, gee, you know, I got hit with tens of thousands for expenses and award, and the claimant, it was a frivolous claim and got 300. That can happen. For us to dig in further, we'd have to know a little bit about it. Just a couple of other key rules is there are the ability to receive interim measures, as in protection, much like a preliminary injunction that you can apply to the panel for to preserve property, for instance. And there's also emergency measures. If your agreement doesn't obtain a pre-arbitration TRO or preliminary injunction within that agreement, AAA provides an emergency.
Let's give John a minute to get back online. Well, while we wait there until he gets back on, Catherine, why don't I throw it to you to talk a little bit about JAMS?
Sure. And John was talking about the fact that AAA does offer some emergency relief measures, and JAMS does as well. You know, JAMS is sort of the younger brother to AAA. It's widely known for domestic arbitrations by companies and legal practitioners. And it's, you know, it's among the largest offered domestically. They also do offer international arbitrations as well. And while they don't offer as many distinct procedures based on the type of dispute as compared to the AAA, they do have separate rules for class action arbitrations, construction disputes, employment disputes, and as I mentioned, international arbitrations. They also administer mediations as well. I had one of those recently with JAMS that involved 4 sets of claimants and 2 different respondents, and JAMS did a really quite a seamless job conducting that by Zoom. And did a very nice job. So they're a well-oiled machine. They've been at this for quite a while. You know, there are some similarities in their rules to AAA. One thing that I would note in reference to the question that was posed in our chat room about, you know, so the perceived imbalance between what a corporation might have to pay and fees and costs of the forum as opposed to an individual. I know that JAMS has a separate filing fee schedule for consumer matters. So, you know, in a commercial arbitration, you know, both corporations might be paying a pretty hefty filing fee for their claims or their counterclaims. But with JAMS, in your consumer arbitrations, the consumer has a smaller fee that they pay to file that. You know, the forum is basically recognizing that they're an individual with fewer resources. And so that hefty filing fee is not going to be an impediment for them because it doesn't apply for the consumer. One thing I like about, oh, sorry, go ahead.
And that's also true of the AAA. We were basically going, I think John was basically talking about the commercial arbitration rules, but if you're under the consumer arbitration rules, the fees are going to be, the payment of the fees is going to be heavily slanted or the, in favor of the consumer.
Right.
John, you're back online. Before I go forward with a couple things about JAMS's features that I like, was there anything you wanted to add besides the emergency measures under the AAA rules?
No, I would just point out there are expedited procedures within AAA for less than $75,000 in dispute, exclusive of interest and fees. And then also relative to dispositive motions, there's the opportunity to bring a motion to dismiss or a motion for summary judgment within AAA, but the standard is somewhat narrow. You're entitled to file it only if the arbitrators decide that the moving party has shown you're likely to succeed on the merits, and then that the motion will dispose of or narrow the issues in the case. And so I've had commercial arbitrators interpret that different ways about whether they're going to apply it to a particular claim on a motion to dismiss or statute of limitations and other things. And I've just had, I'll put it inconsistent. It's just one of the things you face. You're at the mercy of your arbitrators on that.
Thanks, John. But one thing I like about JAMS, even though it's pretty flexible in what it allows for discovery, I think that they offer slightly more defined and clearer baseline standards and rules for discovery. So like the AAA, their rules do provide for a voluntary exchange of information, really the disclosure of witnesses, as well as the production of documents that are relevant to the dispute. That is to be done within 21 days of the service of the pleadings. And then it's to be supplemented. The rules provide that those disclosures and productions are to be supplemented throughout the proceeding. JAMS also specifies that each party can take one deposition and that the arbitrator will decide the availability of other depositions based on the needs of the case. With respect to expert discovery, while the production of reports is contemplated, they don't require expert depositions. Again, that's going to be up to the arbitrator to decide based on the requests made by the parties. JAMS also recognizes there's been a lot of complaints about wide latitude in discovery in arbitration, although the goal has been for discovery to be streamlined in arbitration and less costly. They recognize that the pendulum can swing the other way. And so JAMS has put forth what are known as expedited procedures for discovery. And those are rules 16.1 and 16.2 in their general code of arbitration rules. And the parties can agree to adopt those expedited discovery procedures. And they contain some helpful limitations regarding document requests, ESI, the availability of depositions, and also deadlines to complete discovery in a case. And those are rules that can be adopted in the parties' agreement, or they could agree to those, after the case is, or the arbitration proceeding is filed. And whether or not you choose JAMS as your arbitration forum, I still encourage clients and companies to look at some of the standards that they've offered, including their recommended arbitration discovery protocols that they've published on their website, and to consider whether you want to tweak or modify or adopt in full any of those procedures that they've put into place as part of your arbitration agreement. We'll get into that a little bit more as we talk about the drafting. So those are some of the things that I like about JAMS. Mike, I know that you've handled matters before JAMS quite a bit. What do you like about JAMS?
I honestly, this is my views and not the views of Brush or anyone else, but if it comes down to it, JAMS has got a much better lunch. That's all there is to it. It really does. It's superior.
But it's not free, right?
No, it's not free. No, it's not. You're going to pay for both, but JAMS in New York is going to be superior. But,
good to know.
Thanks, Catherine. Sarah, can you talk a little bit about specialized forums for arbitration in international disputes, as well as private arbitration?
Yes, and I will only mention it a little bit, but obviously there's a lot of international commerce, and there has to be a vehicle for implementing arbitration agreements between domestic actors and international actors. And for this, I just wanted to let you know some of the differences that you might not be aware of in terms of what is available for international arbitration. So the AAA has the International Center for Dispute Resolution, and they administer arbitrations involving international concepts. And there are differences between what they do in those situations and what they do under the general commercial arbitration rules. For example, since you have international parties, language obviously could be an issue in terms of what language are you going to hold the arbitration in. They have a rule that says that the language of the arbitration will be the language of the documents that contain the arbitration agreement. And therefore, if you want some language other than the language of the arbitration agreement, I respectfully suggest that you put that in the arbitration agreement. Otherwise, you could end up having a domestic arbitration that will not be held in English. Second, discovery really is very restricted in international arbitration. Everything is controlled by the arbitrator, and I really mean controlled by the arbitrator from the standpoint of the breadth of document requests. There is a presumption explicitly set out against depositions, interrogatories, and what is explicitly described as American-style discovery. There is the ability to present evidence at a hearing by signed witness statements, but a witness that submits a statement may be required to submit to examination at the hearing, so there can be cross-examinations. The arbitrators can choose to appoint their own expert as opposed to relying strictly on the party's experts. They have to, unlike in many forums, arbitrators have to give what's known as a reasoned award, meaning that they have to give the reasons for their decisions in the award. In international arbitration, there's none of this arguing about, things being equitable and the arbitrator doing things that, are not really in accordance to the law because of equitable principles, etc. No, the international arbitration rules explicitly provide that arbitrators have to follow the law and cannot decide the case based on general notions of fairness and equity. And then last but not least, even if you have no prevailing party provision for attorney's fees, for the award of attorney's fees, in your contract, the rules do contain a provision that allows the arbitrator to split the attorney's fees or require payment of the attorney's fees include by either party and make the other side pay them. So those are some of the differences. I mean, that was essentially the difference if you do it at the AAA. The ICC, which is probably the best known body for international arbitration operating in the US, has some other procedures, including the fact that if your arbitration involves a dispute of $2 to $3 million, depending on the time of your arbitration agreement, or less, you will be subject to expedited procedures that are going to cut down on the cost of the arbitrations even more. And many international parties like to use the UNCITRAL rules, which are the United Nations Commission on International Trade rules. Generally speaking, if you appoint an administrator for that, the AAA will be the one that you will select, and they will administer the arbitration in connection with those rules.
And Sarah, maybe just a short word on private arbitration before switching gears to drafting.
Private arbitrations is for people who don't want to pay the administrator, who don't feel that there's really a need for that. So there's an agreement to how you're going to appoint the arbitrators, how you're going to run the hearings, what are you going to do about costs, et cetera, et cetera. You essentially agree on most of the points that it's going to be necessary to agree to. Then whatever you did not agree to, such as, maybe subpoena power or that type of thing, will be controlled by the state arbitration act of the state where you are conducting the arbitration, or it will be controlled by the Federal Arbitration Act, depending on the nature of your dispute. And if you have a problem getting enforcement, you go see a judge and ask him to control the procedures in accordance with the contract.
John,
A lot of people hate that. A lot of people hate what's called ad hoc arbitration. I think it has a lot of promise.
Well, John, are there any negatives? I know Sarah kind of highlighted a couple, but what happens if you can't come to an agreement? Maybe you have an obstructionist adversary, as we've all encountered.
Right, Michael, exactly. My concern is there's too much elasticity in that process. And I think it all depends upon who your adversary is on the other side, whether that person can be reasonable and come to it, or if they're going to be difficult through it. You know, I think the forums, JAMS, AAA, ICC, the London Court, the others, they've developed all of these rules and procedures to allow some informality. And I think that's a lot to develop from scratch. You've got to have some guardrails. I think also the administrator plays key roles. And raise your hand if you, I'm getting my
No, it's like you're a
telling me that I'm
ventriloquist.
having trouble
Your-
again.
Your mouth isn't
Yeah.
moving, but we can hear you.
Yeah, okay. The administrator plays a key role, and do you really want the arbitrator, you know, making that sausage that the administrator makes? And do you want to be paying the arbitrator their hourly fee for doing that? I think you also run into potential for conflict of interest. You know, Sarah will tell me, well, you've got a problem there. You go back to the court, you get it figured out. But I think the forums have good procedures in place to flesh out conflicts of interest by the arbitrators, by the parties, and by the council and certain.
Okay. Well, I think John's a little.
Add to, there are times, you know, when there are miscommunications between parties. And
Right, absolutely.
when you have the filter of an administrator in a forum, let's just say that miscommunication is made to the administrator. I have an opportunity to clarify that before it goes to the arbitrator. No, we don't have an agreement here. Instead of having to get the arbitrator in the weeds. So I like having that filter between the parties and the arbitrator.
Well, let's switch gears
And
a
I
little
would-
bit, John, if you don't mind, because we only have about 13 minutes
Absolutely.
left, and I want to talk a little bit about the drafting issues. So John, can you talk to our audience a little bit about the potential breadth of an arbitration provision? Well, I'll jump in then. So, because I think John is still a little muted, but I can tell you for our audience that really you can craft these arbitration provisions as broad as you necessarily want. And this is, at the end of the day, a contract. And courts more than likely are going to enforce what two parties to a contract agree to. And there was a meeting of the minds. And there's a number of issues that we're going to discuss briefly and just touch upon that are important to consider when trying to meet in the minds and try to draft your contract provision, such as location, Catherine. Can you talk to our audience a little bit about location issues and scope of discovery issues when drafting your arbitration provision?
I think that John and I would agree, and I'm sure you would as well, that you can have a very broad arbitration provision, or you can have one that's very specific and you know, trying to plan for various contingencies. But we think it's wisest not to overload an arbitration agreement with too many additions or too much specificity, because it is hard to plan in advance for exactly what you're going to need in a dispute. And also, although, you know, crafting various limitations can seem appealing, it's not really going to stand up if it's one-sided. So you know, what's good for the goose is good for the gander, and your contract is going to need to sort of equally apply the limitations in the arbitration forum. And you may just not be ready to do that at the outset of forming an agreement with another party to a contract. And if this isn't some sort of standard, you know, consumer agreement, but you know, a unique agreement between two parties, you also just want to reach your contract and get it done. And if you have, you know, 3 pages of procedures for your arbitration, your potential arbitration, I can see that being an impediment to just finalizing an agreement with another party that you're trying to contract with. So all that's to say, there are certain things that you would always be wise, I think, to include in an arbitration provision. They're just the gimmies. And the first would be the location of the arbitration. You know, if one of arbitration's primary benefits is cost control, certainly identifying the location for where your disputes will be heard with the other party to the contract is going to be a way to control costs, because you can select a location that's going to be most likely more convenient for the likely witnesses, for corporate representatives. You know, you have that benefit certainly in selecting your location and being able to control cost. You know, your location, it would also impact your arbitrator pool. Some people do prefer certain areas of the country for their arbitrator pools, and you know, by choosing your location, you have the ability to do that. It can also provide a basis for the applicable law for your dispute, and we'll talk in a moment about applicable law or governing law provisions in your agreements. But certainly, if you prefer a certain jurisdiction's laws and you have chosen that jurisdiction as the location for your arbitration, that's going to be sort of by default the law that would apply to your dispute, to your arbitration. Certainly the arbitrators have some flexibility. They might get into the conflicts of law principles and choose some other law, in which case, yes, you need to be defining the law in your agreement as well if you have strong opinions about that. But the location for your arbitration can help bolster your applicable law provision or be the determiner for what law is going to apply to the dispute. Couple other thoughts on choosing the location and specifying it in your agreement. In contracts between commercial parties, arm's length transactions, the location that's identified is generally always going to be enforced. And even in in consumer arbitrations, the location specified in the agreement is probably going to hold up. But obviously you don't need to pick a location that bears no reasonable relationship to the matter, to at least one of the parties, as that would be shut down as unconscionable or against public policy.
All right, great. And just for everyone, we try to highlight by bullet point in this PowerPoint slide some of the factors that one should consider when drafting their arbitration provision. But John, you're back. Let me throw it back to you. And could you talk a little bit about, in the drafting context, the allocation of fees and costs of the parties in a domestic arbitration? John, I think we can't hear you. Well, I can jump in there and when John gets back, but can you hear us, John?
We can't hear you, John.
It's okay. We can't hear you. But look, with domestic arbitrations, the parties are free, at least in the commercial world, to allocate fees and costs. And you're allowed to have prevailing party provisions, though that is often a deterrent effect for frivolous pleadings if the other side knows they're going to have to pay the other side's fees. And so certainly we counsel our clients to strongly consider whether the allocation of fees or costs is appropriate for their arbitration provision. Keep in mind, however, that many times we're on the defensive end of things. And to the extent that a business would make a mistake now and then, it's not unheard of, it's not anyone's fault. To the extent you're dragged into an arbitration and you have a prevailing party provision, that can be held against you as well, because you're going to be liable for paying the other side's fees and costs potentially, or at least an allocated share. One other note, and I'll throw it back to Catherine on applicable law, is that we've seen, and I think we talked a little bit about this yesterday, we've seen a body of law out there where there is no prevailing party provision in an arbitration agreement. Nothing about allocation of costs. But an inexperienced attorney would file a statement of claim in arbitration and use boilerplate language in the whereas clause asking for compensatory damages, consequential damages, attorney's fees and costs. They just throw that in there. Well, if the other side in their response also asks for attorney's fees and costs, we have seen the tribunals say that in and of itself is a meeting of the mind on contracts. And in fact, they're going to award fees and costs to the prevailing party at the end of the arbitration. So just keep in mind, you don't necessarily need a contract, although it's always wise to have one, and be wary of boilerplate language in your statement of claims being held against you. But with that said, Catherine, let me throw it back to you on some drafting techniques regarding the applicable law and the defining the forum in an arbitration context.
Sure. And I need to jump back to maybe just address just a couple of points on discovery, as I skipped over that earlier, but to note that it is difficult to know in advance sometimes exactly what you need in discovery. But we heard earlier from John and from me how the rules of the forums, AAA and JAMS, for example, are not very specific in terms of what you're entitled to. JAMS, I think, provides a little bit more guidance that the parties may want to adopt those expedited procedures. So, depending on what forum you're in, or if you just want to have it hammered out in your agreement, you can provide for specific types of discovery in your arbitration clause. You may want to specify a number of depositions. Maybe you don't want to just, go with the one that you're going to get from JAMS or the question mark that you're going to get from the AAA, but specify that each party can take up to 3. And you could highlight what the duration of those depositions would be, the maximum duration or the deadline in which those must be completed from the date of the pleadings being served. You could also, specify discovery cutoffs and things like that. I just would encourage parties and companies to allow some sort of safety valve in that discovery aspect of your arbitration provision to say that for good cause shown, your arbitrator can do X. Because you just don't know sometimes until you're in it exactly what you need. And while it, like I mentioned earlier, while it can be tempting to impose limitations that would hamstring the other side, it applies to you as well. So you have to be careful there. As for applicable law, what you want to govern the party's contract or the party's relationship is really going to depend on the business that you're in and the types of disputes that you're normally subject to. So you're going to want to consult with your counsel in making determinations regarding applicable law. But certainly strongly consider including it in your agreement, because I think, as John mentioned earlier, if you haven't hammered it out in your agreement, it is up to the arbitrator to decide what is the appropriate law to apply. And also keep in mind too, as you draft these governing law clauses, that they may or may not apply. Like, step back a little bit. If you have a governing law clause that applies to the agreement itself or to the party's relationship, the law is less than clear as to whether that governing law clause applies to your arbitration provision. There are cases that are less than clear in that regard. So I would suggest that, perhaps you have a governing sort of substantive law provision that you want to apply to any dispute, the merits of any dispute between the parties. But consider having a specific provision in your arbitration provision regarding what law applies as to the arbitration agreement itself. And the reason that's important is because you have state arbitration acts, and then you have the FAA. You may be located in a state, you may have selected a state's substantive law to apply where the state arbitration act is more hostile to arbitration, and you don't want that. Or the state arbitration act potentially provides broader bases for appeal. Perhaps you don't want that as well. So you want to be clear in your arbitration provision that the FAA governs the questions of arbitration in your dispute. And I should also note that sometimes you have state arbitration acts that are more favorable to your client. Some state arbitration acts might prohibit the awarding of punitive damages in arbitration. So the point there is just to be specific. Don't assume that an applicable law clause in one section of your agreement is necessarily going to apply to your arbitration provision.
Thanks, Catherine. And just a couple other points, because I know we only have a couple minutes left. You certainly should consider in your drafting your arbitration provision, communications with the arbitrators, what are the limits of that, scope, defining the form of the arbitration award, and so on. We only have about 2 minutes, so I'm actually going to just take the reins and just say a couple of things on appeals. Certainly you'll have limited rights to appeal in arbitration. It's only a gross abuse of discretion is something going to get reversed in arbitration. And that's a positive in a lot of ways, because you're going to get finality. It's going to end. It's going to end. You're hoping it ends the way you want it to, but it is going to end. Whereas you can be very successful in a courtroom litigation and the other side can still drag this out for years with appellate review. But if you lose in court, you at least get that appellate review. But with that said, with only a couple of minutes left, we are coming to a close here. And although we might not have gotten to everyone's questions, we're always available, anyone on this panel, to answer any questions that you have offline. We hope you've enjoyed our highly experienced panel, who hopefully assisted in identifying issues, both good and bad, at least perceived, with arbitration litigation, and what would fit the size of your business uniquely. With that said, let's see if we changed any minds. The last polling question of the day. Can we answer it just one more time? Which forum do you prefer? Arbitration or courtroom litigation? Give it a couple of seconds. If it's 51:49, oh, I'm going to give the last CLE code too. That's a good point. I saw that in the chat. All right, well, I guess it's inch up in favor of arbitration. Lauren, you lose. Sarah, you win. Catherine, you win. But let me give you the last code word. So the final code word is turtle.
Win.
Turtle. It's turtle. Turtle. Fear the turtle. For those of you who are sports fans. With that said, thank you very much. We've all enjoyed having you attend today. Please reach out to us at any point in time afterwards. We're happy to answer your question offline. So the first code is fear, second code word, turtle. Thank you.
Thank you.